Hello, Michigan Realtors, and welcome back to From the Mailbag. Thank you for joining me as we take a look at legal questions trending in the real estate industry. I'm Rebecca Jean, and today's Q&A will talk about errors in square footage calculations and whether a realtor can be held liable for those miscalculations. Question 1. I'm a listing agent. A buyer recently purchased my seller's home and discovered after closing that the square footage is less than what was advertised on the MLS. The listing stated that the information provided was not guaranteed and should be independently verified by the buyer. Will my firm be held liable for this miscalculation? Probably not. Several years ago, the Michigan Court of Appeals heard a case very similar to this. The court held that the realtor was not liable, and the court's ruling, similar to cases decided elsewhere, centered on the question of whether or not the buyer could have reasonably relied on the square footage information provided in the listing. Since most court rulings on this topic have hinged on reasonable reliance, realtors would be wise to describe the square footage as an estimate and to encourage buyers to independently verify the information. It's also a good idea to use limiting language on the MLS and in the purchase agreement that disclaims any liability for inaccurate information. This isn't a fail-safe, but a number of courts have used the existence of such language as a basis for determining that a realtor is not liable for errors in square footage information. Question 2. I've heard that there are often mistakes in the square footage calculations contained in the tax records. Should I take my own measurements of the homes I list for sale rather than rely on the square footage information in the tax records? Square footage calculations are difficult. Rather than assume this responsibility, a listing agent may wish to advise a buyer that the square footage information is not guaranteed and that the square footage figures should be verified by the buyer. Question 3. My client's purchase agreement was contingent upon the home appraising at or above the agreed upon purchase price. The home appraised above the agreed upon price, however, the appraisal shows that the home was about 300 fewer square feet than what was represented in the MLS listing. Can my buyer terminate the purchase contract? Michigan courts have not yet addressed this issue. Arguably, the purchase agreement is voidable not based upon the appraisal contingency, but on the basis that both parties were mistaken about a material fact, that is, the number of square feet in the home. Buyers who are concerned about square footage may wish to include a provision in the purchase agreement making the contract contingent upon the buyer's verification of the square footage figure. Thank you for tuning into another installment of From the Mailbag. For more info on this topic, be sure to check out its companion Letter of the Law video, which is linked in the description. Please send any questions or suggestions for new topics to the email listed below. Based on input from you, as well as the Michigan Realtors Legal Hotline, our legal team will continue to work on content to help you as a realtor. Again, thank you for watching, and we will see you next time.